Hi, my name is Stephen Montagna and I practice out of Solano County.
Hi, my name is Leena Hingnikar and I practice out of Los Angeles County.
Today we're here to discuss the additional steps and forms you'll need when starting your divorce case.
Stephen's going to start with the summons form.
When you file for divorce, along with your petition for dissolution, you'll be required to file what's called the summons, the FL-110 form. When filing the FL-110 form, it's going to be important that you include specific information with respect to your name, the opposing party's name, which is referred to as the respondent, the address of the court, as well as any information related to an attorney.
Stephen, what's the purpose of the summons?
Well, the purpose of the summons is to provide notice to the opposing party that, one, the case has been started. In addition, it also provides information on the type of conduct that you can and cannot do when the case is progressing. We would also need to include information such as if you have an attorney, their contact information will also need to be provided so that you can reach out to their attorney. Anytime that you're filing paperwork such as a petition for dissolution in the summons, it's important that those documents are served personally and that you also fill out a proof of service.
And file that proof of service with the court.
If you are the respondent and you are served with the FL-110, it's important to note that there are timelines that are attached to the summons, specifically that you have 30 days to respond. Do you know what happens if you don't respond?
No, what happened?
What's interesting, the court can make orders without you as it pertains to child custody, support, property division, and attorney fees. In addition to being notified that the action is started, there is additional information that is contained on the back of the summons, which provides notice of restraining orders that take into effect as soon as the case begins. These are found on page 2 of the form, and they are called the Standard Family Law Restraining Orders. For the filing party, the standard restraining orders go into effect upon the filing of the action. Whereas when you're the respondent, these restraining orders only go into effect upon when you've been served. The standard family law restraining orders prohibit you from doing the following: leaving the state with your children or applying for a passport without the written consent or court order.
What if I have to go on vacation?
Unfortunately, the family law restraining orders prohibit you from doing that without getting written consent from the other party or a court order.
Does that mean you can't move?
Yes. The family law restraining orders also prohibit you from moving unless you get written consent or order by the court. In addition, you are prohibited from canceling health insurance. Do you know any other types of insurances that they would be prohibited from canceling?
Car insurance, life insurance, basically any type of insurance you cannot cancel once the divorce process starts.
What about homeowners insurance? Does that also qualify?
I think so.
It does. The restraining orders also prohibit you from transferring, concealing, liquidating any type of property, personal or real, without the other party's consent or knowledge.
In addition, you must also notify the other party of any extraordinary expenditures 5 days prior to making that expenditure.
Are there any exceptions to these expenses or expenditures?
Necessities of life or attorney's fees?
So that pretty much sums up for the summons part of starting your case. And remember, it's very important that you pay attention to page 2 and the language that's contained on the standard family law restraining orders.
If your case includes minor children and custody issues, you will have to fill out the form FL-105, which is the UCCJEA form, and that is form FL-105. This form basically gives the court jurisdiction over your children and provides the court with all the information that they need to know about your children and where they have lived for the past 5 years and who has custody of them and how things are working for the family right now. So first you're going to fill out boxes 1 through 3. Those are basically your general information, your name, your address, all of that stuff. Those boxes should match on every single form that you're filling out to file for divorce. The second box should include the court information, and that again should be the same as all your other forms. And the third box should be your name and the respondent's name, or if you're the respondent, the petitioner's name, because whether you're filing for divorce or whether you're responding to a divorce, you have to fill out this UCCJEA form. It's mandatory for both parties if there are children. If there are allegations of child abuse or domestic violence in your matter and you wish to keep your address and your children's address confidential, you will have to check box 2 on the form, and this basically allows you to not include anybody's address on the form when you fill it out. So item 3 is where you list your first child can be any one of your children. You are going to list their name, date of birth, their place of birth, and you list their addresses for the last 5 years. If they've lived in more places than there are boxes for, you will have to attach a form to the UCCJEA form in order to list all the addresses that they've lived at for the last 5 years. The box following is where you list your second child if you have another child. If that child has lived at the same addresses as child 1, you don't have to list everything all over again. You just check the box that says if the information is the same. If they have lived at other addresses, you're going to have to list every single one of those out as well. If you have more than 2 children, you will have to check the box that says so and attach another attachment to the UCCJEA, which lists all of that child's information and where they have lived for the last 5 years, and so on and so forth, depending on how many children that you have.
And remember, this form applies to children from your relationship, whether it's in a marriage, whether it's in a UPA case, also if the child is adopted.
After item 3, you move on to page 2. Don't forget to fill out the top part of page 2, which lists the short title of your case, which is basically, if your name is John Smith and your wife is Shelley Smith, you would put Smith versus Smith and fill out the case number if you have one at the top of page 2. Then you move on to item 4, which deals with whether your children have been the subject of another custody proceeding or any other type of court proceeding in any other jurisdiction or even in the same jurisdiction. So you'll need to check the appropriate box indicating whether your children were a part of another court proceeding or not. You'll need to fill out which children were a part of that court proceeding, what the court proceeding was about, what the case number was, whether there was a judgment, and what your connection to the court proceeding was.
So does this mean that if I have a restraining order case in a different county, I have to list this information?
You do, and that's in box 5. So if there's any domestic violence, restraining orders, or protective orders in place, you will have to fill out box 5, check the appropriate box, whether there is or isn't, and then list all the relevant information about the case, the county, the state that it took place in, the case number, and when that order expires. If there are any other individuals who are not a party to the case that's taking place between you and the respondent or the petitioner, who might claim that they have physical custody of your child or children, or claim that they have visitation rights with your child, you will have to check box 6 and check the appropriate box and list all the relevant information relating to this person and basically why they have a connection to your child. At the bottom of the form, if you had to attach any pages to the UCCJEA for your additional children or any other reason, check that box, write down how many pages you attach so that the court makes sure that it has the full UCCJEA when it's filed, and don't forget to sign and date, and that's how you fill out your UCCJEA.
And remember, you have a continuing obligation to inform the court if this information changes with respect to your child's address.
At any point in time during the proceeding.